Live, local, late breaking. You're watching KOLD News 13 live at 10.
And it's really sort of shocking to think about it, that this case was filed in 2012, that it was supposedly settled in 2000, at the beginning of 2015, and here we are.
Those in charge of Arizona prisons are about to face a judge defending the department against allegations it failed to provide adequate health care to inmates across the state. Thank you for joining us. I'm Brooke Wagner. It's a case investigative reporter Shaley Sanders has followed for years, and she joins us now with the latest as we are now just days away from the trial.
This trial comes after years of failure by the Arizona Department of Corrections, Rehabilitation and Reentry to meet inmate health care performance measures they agreed to in a settlement. A federal judge said enough is enough, threw out the settlement, and ordered the parties to go to trial.
And how long have you been a part of this case for?
Since it was filed in 2012.
Dan Barr is one of the attorneys representing the 30,000+ inmates in the Arizona Department of Corrections, Rehabilitation and Reentry.
Did you think that you would be going to trial after reaching a settlement in 2015?
No, we all expected the state of Arizona to comply with the settlement, and they never could do it.
This settlement includes more than 100 performance measures that would improve inmate health care, but the department has struggled to meet many of the benchmarks. In 2018, a federal judge issued a fine of $1.45 million after it found the department to be in contempt. In our September 2019 investigation, I obtained copies of temperature logs from facilities across the state. Those showed some units reached 115 degrees, while other logs were only partially filled out or entirely blank.
Either there's no information, there's erroneous information, there's information that appears to be falsified. They had at one point filed logs with the court showing temperatures for dates into the future. They said that was just a typo.
Attorney Corrine Kendrick with the ACLU National Prison Project has also worked on this case from the beginning. One of the issues Kendrick reported had to do with the violation of a mental health order. One of the judge's orders required inmates on suicide watch to be seen a minimum of 10 minutes, and counseling appointments needed to be at least 30 minutes, with exceptions for meaningful encounters.
We presented evidence showing that there were hundreds of encounters where the department had said, oh, we're complying with the order, even though the encounters were very short, and every single one they said was meaningful.
As we reported in February, the ACLU documented incidents where patients on suicide watch were reportedly seen for no longer than 5 minutes. The ACLU reported one patient killed himself a few hours after being taken off of suicide watch, while another was taken off of suicide watch after a 3-minute encounter and killed herself 4 days later. The department has now faced more than $2 million in fines for failing to correct the issues.
You've had several federal judges issue orders sanctioning the state, several federal judges, writing, critical opinions about the state's lack of performance. I mean, if you'd have to just glance at Judge Silver's 36-page order that she issued in July, and it's highly critical and pretty damning.
That order states, quote, over the past 6 years, defendants have consistently failed to meet many of the stipulation's critical benchmarks. Beyond these failures, defendants have in the past 6 years proffered erroneous and unreliable excuses for non-performance, asserted baseless legal arguments, and in essence, resisted complying with the obligations they contractually, knowingly, and voluntarily assumed. She ordered the trial to begin no later than November 1st.
At this point, I mean, there's nothing left to do but to try the case and see if we get more adequate remedies.
Barr says some of those remedies could include ordering the state to hire more health care workers. He says Judge Silver could also follow California's lead and appoint a receiver who would independently determine how to supply health care to inmates. Attorneys, including some who work with Barr, have run into problems while preparing for trial. Take a look at these court documents I obtained. One attorney attempted to depose an inmate when she says someone deployed pepper spray or a similar substance next door, which made its way into the room they were in, making it impossible to continue. Attorneys have also had major internet connectivity issues while in the prisons. Well, since then, the state says it did test its video conferencing equipment and should not have any problems during the trial. The court just ordered the state to file a statement by tomorrow morning confirming testing was performed and there were no technological and non-technological issues like excessive noise, pepper spray, and scorpions. Those were identified during the recent prisoner depositions. I asked the Arizona Department of Corrections, Rehabilitation and Reentry for comment as they prepare for trial. I'm told they do not comment on pending litigation. I also emailed the governor's office twice for comment and did not receive a response. Shaley Sanders, KOLD Investigates.